Thank you, Mr. Representative of the Workers' Committee, workers, members of the media. I am very happy to be part of this battle on your behalf against NGC and, if necessary, the government of Trinidad and Tobago to pressurize your employers for whatever reasons and to indirectly and directly affect the lives of the workers. As I came here this afternoon, I must confess, I remembered some of the battles over the last 50 years I have been involved in. I know I do not look so young, but I remember that when Caroni was closed down, the workers felt that they would not get their land that was promised to them, and there were audiences like these, and we told them that if it's one thing that the government had to do was to keep their promise to give the workers the land that was promised. And there are many other battles. So I know how you feel today. I know how you feel. You have been reading a lot of things in the newspapers, and therefore I thought it was best to accept the invitation to come to you this afternoon and to tell you and to tell the entire country, because this meeting is being carried live from 4:15 until 5 o'clock on many radio stations. And therefore, a lot of people in Trinidad and Tobago will know the truth about what is happening in this matter. I would first like to tell you that there are two persons here who are part of the legal team, Mr. David Mark Kidney and Ms. Sastia Samlal. They are from the firm of Ronnie Bissessa and Company, and they are here with me this afternoon in respect of this matter. Now, what I propose to do this afternoon is to go into this whole matter so that you can understand it. And it's important for you to understand it, because when you understand it, you would realize what is happening, and you will be the jury, the judge and jury of what is happening. I want to give you the assurance, however, before I start, that these companies are not going to close down. The government would not be able to do it, and you are not going to lose your jobs, because we are going to fight by every means in order to save your jobs. But I want to be honest with you, there is a severe threat against your security as workers, because things are being made difficult, not because your employers committed any wrong. They did not commit any wrong, because a court order does not have the name of your employers. So I want you to bear with me so that I'll be able to explain this issue to you. You are the most important people in this affair, and therefore you should know what is happening. The first thing I want to tell you is that the issues which are involved in respect of your future as workers are important. And the reason that they are important is not only because they are important to you. The reason it is important is because the Constitution of Trinidad and Tobago, which is the supreme law of Trinidad and Tobago, guarantees to every individual, which includes a company, because a company in law is an individual. It's just like a human being. It's regarded as another person. So it gives to every individual the right to enjoy his property. Now, property under the Constitution of Trinidad and Tobago is not only land. Property involves money. It could mean your job. It could mean many things. Goodwill of a company. And it says that nobody could interfere with your property, deprive you of its use, or interfere with you, except by due process of law. In other words, there must be a court order to interfere with property rights. Now you may ask yourself, why am I telling you this? Your employer, which is a company, there are about 5 companies, your employer is an individual. And your employer right to the enjoyment of its business, its property, and therefore your employer as a company, its business cannot be affected in law without a court order preventing it or restricting it. And if NGC or any state authority does that, it means that they are violating the Constitution because they are depriving your employers of due process of law. And that is why when you go home or you have children, you ask them to read Section 4A of the Constitution of Trinidad and Tobago, and it makes it clear. And no government, no state agency can violate the Constitution, because then your employer would be entitled to redress. But it goes further. There is a famous case from Mauritius, which went to the Privy Council, which is the final court of appeal for Trinidad and Tobago. And it says that in respect of a company, the goodwill of a company is also part of the property rights of the company. And therefore, the goodwill of the company would include its staff, its workers, the workers' rights. So therefore, if you take action against a company, and the company workers and the workforce are being affected, it's like if the government is interfering with the property rights of the company. I am telling you this because you will see that from what I am going to show you, notwithstanding what NGC is trying to say in whole-page advertisements that they have paid for and put on the newspapers, because I call one press conference to talk about it. And they print in whole-page ad. So I want to know, if I start to mobilize the country on this issue, how many ads they would have to print. So contrary to what NGC is saying, I would show you that they have tried to use, and they have used the court order against SIS to prevent Prime from shipping goods abroad. I can't go into all the details, but I'll show you, and I'll explain it to you. Now, you may ask the question, why is all this thing happening? Well, I do not know. But you have told me, some of your representatives have told me, that you believe that there's political interference and manipulation of public power to adversely affect your interests and the interests of your employers. Well, I want to tell you, if that is the reason, if it is that because the government believes, or NGC believes, that your company or anybody associated with your company supported a political party which they are against, and because of that they are oppressing you, that is unconstitutional and that is wrong. And if it's one person in Trinidad and Tobago who is going to stand up against that, is me. And I'm prepared to fight that to the end. Because the Constitution of Trinidad and Tobago does not give any government, the right to harass or intimidate or interfere with the rights of a person purely because they express political views or they are associated with another political party. I want to tell you, I have, in my experience as a lawyer, and in my experience as a former Attorney General, and as a social worker in Trinidad and Tobago, I have looked at this matter objectively, fairly, and I did that in order to come to you and to tell you what I see very objectively, what is the position in this matter. We must always be vigilant because we want to ensure that no government, no state agency trample upon our rights. I am of the firm opinion that a grave injustice is being perpetrated against these companies which are your employers, and that a grave injustice is being perpetrated against its workers. And therefore, those of you who are listening on the radio this afternoon, I want you to understand that this injustice cannot be tolerated, because if it is, that this can be a precedent in Trinidad and Tobago, then we would be living in a police state. Your employers, Phoenix Welding and Fabricating Limited, Quality Refractory and Installation Services Limited, Point Lisa's Construction Limited, Jani King Limited, Scaffold Professional Limited, Professional Coatings Limited, and Prime Equipment Rentals Limited are companies which are not owned by SIS, which operate as separate legal entities. They transact their own businesses with other companies, and also they transact business with SIS. These companies have separate workers. They are not owned by SIS and are not subsidiary companies of SIS. There is a court order which I'll explain to you, which was made ex parte, that is in the absence of SIS and its lawyers, and it was not made, but it was not made against these companies. Notwithstanding that, however, that the court order has been made only against SIS, and it is not made against your employers, this court order is being used against your employers, and it is affecting their banking business, it's affecting their trading business, and it's affecting almost 800 workers. This hall is full today, and that gives me an indication that we have approximately 600 or 700 people here today. 600 or 700 or 800 workers with the average of 5 persons per household is 4,000 persons. It involves the future of children. That, to me, is sufficient reason for me to stand up against any state agency or any government to fight for their rights. The wrongful use of the SIS court order against these companies have resulted in some of the workers not being able to use their own personal banking accounts, and they are not being able to receive their salaries in time. Now, get it clear. It is not because the companies do not have money in the accounts. The companies have more than sufficient monies in their account to pay salaries and to pay their bills. And if there's an order against SIS, how it is that the personal banking accounts of the employees can be affected. And I've seen evidence of some of the personal banking accounts of the employees being affected. I'll explain to you that the court order made it quite clear. Court order made it quite clear that things like salaries cannot be affected. And if it cannot affect SIS company, how it could affect your companies, your employers, when it's not SIS we are dealing with? Your employers, some of them have not been able to pay their suppliers. When they write the check go to the bank and the bank keeping it. Not that the account doesn't have money. The account has money to pay. But if the suppliers do not get their money, they won't supply the company. And therefore, if that goes on for a while, that is to strangle the lives of the company. If they're strangling the lives of the company, they're strangling the workers' lives. They're strangling the children's lives. They're strangling the lives of the families. And that is what is happening in Trinidad and Tobago with a court order that does not affect the employers, your employers. About a week ago, when I got some of these facts, I called a press conference at my law office. I made this matter public. NGC is vexed because I make it public. They want it only to be kept in the confines of the courthouse. Well, I want to tell them that I'm a public man. I believe in publicity, to expose things. And therefore, they cannot affect my freedom of expression. If they want to do it, let them try. I expected NGC, after that press conference, to have considered the public interest and to have realized that a grave injustice was being done to these companies and their workers. NGC, however, has decided to embark upon a battle against me by using taxpayers' monies to print full-page ads and to print matters which are not true. I would have thought that NGC would find it better to utilize those monies in the spending of those ads to improve the salaries of their workers and to improve their benefits. But they believe in spending taxpayers' monies to print ads. I wish to inform NGC that I consider the statements published, which they have published in the newspapers, to be untrue. They are defamatory, and I have sent that information to my lawyers in London with instructions that if it constitutes libel, that I would commence legal action against NGC for its defamation against me. Let me discuss this matter now, the facts of the matter. You know, in discussing it, I will have to go into the order which was made against SIS. SIS tendered and was awarded the contract for the Beetham water recycling plant. Following the general elections, the contract was terminated with effect from the 4th of December 2015. NGC filed a claim in the High Court against SIS, claiming that NGC overpaid SIS. The claim by NGC falls to be determined by arbitration because the contract provided that if there was any dispute, there must be arbitration. SIS has denied that it owed NGC any monies. I have examined the documents which I obtained, and they have denied that it owes NGC any monies. So there's a dispute between NGC and SIS as to whether any monies are owed. And SIS has started the arbitration process for the arbitrator to determine that issue. In the meantime, however, NGC went to the High Court, ex parte, that is in the absence of SIS, and made an application for the court to make an order against SIS so that it would not remove from Trinidad and Tobago assets to the value of $180 million, because that is the quantum of the claim which NGC has filed against SIS. The order states that the asset included any asset which SIS has the power to dispose of or to deal with. What happened is when the judge made that order and the matter was called up, another judge, Justice Margaret Mohammed, decided on the 29th of December 2015 to make it clear that the order did not affect or freeze the bank accounts of SIS. So the judge made that clear in the order, and I have that in writing. Paragraphs 10 and 18 of the court order made it clear that the court order did not prohibit SIS from dealing with or disposing of any of its assets in the ordinary or proper course of its business, and further that no bank need to inquire as to the application or proposed application of any money withdrawn by SIS if the withdrawal appears to be permitted by the order. So that means that in the ordinary course of business of SIS, the order did not affect it. because SIS should be able to conduct its normal business. The purpose of the order was that for NGC to get security for $180 million of its assets. And I will tell you what SIS offered to NGC for that security. Bearing in mind that no case is determined yet, this is just an interlocutory order before the determination of the case. The purpose of this order was to ensure that pending the determination of the case between NGC and SIS, NGC would have security for any judgment if it succeeds ultimately in the claim that was made against SIS. So that is the whole purpose of that order, to provide security for NGC, so that SIS would not dissipate its asset, that is to sell its assets and etc. So if it loses the case, NGC would have no money. That is the reason why the court, in granting the order, made it clear that the order, in the order it says, this order can cease to have effect if security in the sum of $180 million is provided by SIS. So the court decided that if SIS put $180 million into court, that is the end of the case. And the court says if SIS provided security, that is land and building and etc., worth $180 million, and NGC agree, that could be the end of the matter. The whole object of the court, having such a jurisdiction to make an order for security, is to ensure that while a case is pending, people do not dissipate the assets. So the purpose of such a court order is not to close down business. It's not to prevent it from trading. It's not to do it in such a way that the banks examine every transaction, every deposit, every salary, personal bank accounts of workers. That is not the purpose of such an order. And the order, in effect, says so, expressly. I have been supplied with information by some of you, and it has provided relevant information to support statements I made last week in my press conference. Since then, I've been provided with more documentary evidence and other information which I would share with you today and share with the national community. Based on that information, I can tell you that subsequent to the court order, which was against SIS only, NGC, through its lawyers, in a letter took the position that in respect of goods which were to be shipped by Prime to the USA, that the goods were owned by SIS and that Prime was a subsidiary company of SIS. NGC wanted an undertaking to be given that the goods would not be shipped. I have seen the documents which have been sent to NGC, which show that the goods were not owned by SIS. Also that Prime is not a subsidiary of SIS. Also that the goods were owned by Prime and that there was a contract entered long before the elections last year between Prime and a company in the USA for the shipment of those goods. Notwithstanding that Prime was not part of the order made against SIS, and notwithstanding NGC did not produce any evidence that SIS owned the goods or that Prime was a subsidiary of SIS, Prime has been prevented from shipping the goods to the USA. That is true. That is a fact. NGC knows that that is a fact. Prime has lost approximately $750,000 US because it broke the contract to ship the goods. And the company is losing money every day because it has not been able to ship the goods. I asked the question aloud. Does somebody want the company to lose so much money that the company would have to close down? And if the company have to close down, with somebody who is connected to big conglomerates would want to buy up the companies? Is that the reason? I want to know. Prime made 3 attempts to ship the goods. The last one was on the 30th of January 2016. I am informed by witnesses who were present at the port in Point Lisas on that day that customs had given approval for the goods to be loaded onto the ship, and this ship was chartered specially to come to Trinidad to take these goods to the USA. The witnesses informed me that whilst the goods were being loaded, after the customs gave approval for the goods to be loaded, 2 NGC officials came whilst the ship was being loaded with the goods, and they made inquiries into the shipping operations and then left. And do you know what happened shortly thereafter? Let me tell you what happened shortly thereafter. Shortly thereafter, the same custom official, gave instructions that the loading of the goods must stop. You have to unload where you load. Then shortly thereafter, police officers came, a whole ton-load of police officers, took possession of the custom documents, and Prime was not able to ship the goods. The chartered ship leave empty, going back to where it was chartered from. Is that right? You'd recall from what I told you, the court order stated that if SIS provided security for the sum of $180 million and NGC approved that security, the court order would cease to have effect. Well, let me tell you what SIS did. SIS say, listen, we are not guilty of what you're accusing us for, but we will give you security, and we won't give you $180 million security. We would give you almost $300 million security. And it provided the properties, the valuation by independent, reputable valuators. It showed that these properties are unencumbered, and that in respect of the mortgages and the debenture which it had, that the persons who had that in their favor said they were paid off and they are prepared to release the properties. So NGC has been offered more than $180 million in security, properties, by SIS, and NGC not approving for the release of the debenture and the mortgages. So what is the motive? I ask you to judge, what is the motive? Why would a court provide a security, you get a higher security, and you know workers going to suffer because they're suffering and you know about it, but you're not accepting it? If NGC takes steps to have the security for the amount, then the court order would have no effect. And then all these problems with the workers and etc. would stop immediately. Because I sympathize with the banks. The banks are totally confused. The banks are totally confused, and I will show you how NGC, through its lawyers, wrote a letter to all the banks and sent them a copy of the order and what they ask. So the banks are confused, and NGC is not taking any steps to clarify the issue. A state agency has a duty in these circumstances to clarify the issues, to ensure that 800 workers and their families do not suffer. So I have shown you, therefore, and I want to tell you, I have seen the evidence. I have seen it. I have shown you, therefore, that NGC, although they put all this ad on the papers, NGC has attempted to bring assets of another company, Prime, under the umbrella of the SIS order, which has affected the trading rights of Prime. And they have made the allegation, pure mere allegation, without any proof, that Prime is owned by SIS and that the goods belong to SIS. Now, I am not the lawyer for SIS. You have a lawyer there for SIS. But I have been able to make my investigations. You have given me some information, and I've been able to make my investigations, and I've seen the documents. I've also shown you that it is possible for NGC to take steps to have the $180 million, the subject of the litigation, to be secured by properties worth more than $180 million. Now, these workers who work in these companies are not only UNC. You have UNC, you have PNM, as the chairman said, you have people from all walks. Some people are not in any political party. So if it is that a state agency, knowing of all these problems and does not take steps to try and solve the problem, then you have to ask the question why it is not taking those steps. This is not a case of a man who owns a company, SIS, and he said, listen, I have a case, I write, I'm not giving you any security. The man is saying, listen, you're wrong, I write, but you want security, I'll give you security. Wouldn't that show I have no intention of dissipating with any assets? You have more than the security than you require. Now, it is clear that the problems which have arisen, for example, with the salaries and with the suppliers' checks and etc., that has arisen, those problems have arisen because the banks have not been interpreting the order properly. And it may be the way NGC has handled this matter and what they wrote to the banks have caused that. This has resulted in the banking relationship between the employers and these companies to be affected tremendously. And therefore, I want to show you what is the position with the banks. Now remember, I told you that the court order made it clear that SIS bank accounts were not affected or frozen. Well, if the court order did not affect SIS bank accounts and did not freeze SIS bank accounts, how could the court order affect the bank accounts of the employees of another company, and how could the court order affect the bank accounts of other companies? If it didn't affect SIS bank account, how it could affect the other company's bank account? So what is happening here is taking people for fools. Similarly, the order in paragraph 10 of the court order expressly stated that the order does not prohibit SIS from dealing with or disposing of any of its assets in the ordinary proper course of its business. Well, if the court order says that that cannot affect SIS, it does not prohibit SIS from disposing any of its assets in the ordinary course of its business, then how could it prohibit Prime from shipping goods abroad when that is in its ordinary course of business, but the court order is not against Prime? Similarly, in paragraph 18 of the order of the court, it says that no bank needs to inquire as to the application or the proposed application of any money withdrawn by SIS if the withdrawal appears to be permitted by this court order. The order against SIS therefore does not prohibit monies from being withdrawn by SIS for its ordinary business to pay its suppliers. And if it is that it cannot prohibit SIS from doing so, how it could prohibit your companies, your employers, different companies from doing so, how it could affect your salaries, how it could affect the suppliers who have got their payments, when there is sufficient monies in the account. I have been able to examine the records. There are sufficient monies in the accounts. This is not a case of a company doesn't have money and the company cannot afford to pay you. Your companies could more than afford to pay you. So the court order didn't authorize anything like that. I also have information of a letter, and I've seen the letter, which was sent by NGC lawyers on behalf of NGC to all the banks. Don't ask me how I get the letter, but I got the letter. In that letter, the letter stated it gave notice of the terms of the court order, and it called upon all of the banks to notify them by way of email communication any or all dealings with any of the assets of SIS, held with or secured by the bank, and that the breach of the terms of the order constituted a contempt of court prohibited by fine and imprisonment. Now, the court order did not authorize that. The court order did not authorize NGC to do that. As a matter of fact, what was done, in my view, was against what the court order. And it may be that this letter which NGC sent to all the banks has caused all this confusion. And therefore, NGC has a duty to withdraw that letter. It does not seem to me that SIS court order permitted NGC to send the order to all the banks. It also seems to me, by what was done by NGC, it is inconsistent with the order made by Justice Margaret Mohammed that the order did not affect SIS bank accounts to freeze them. The letter, in my view, encourages the bank to breach their client-banker confidentiality relationship. I am not, as I said, SIS lawyers, but I think SIS is entitled to ask NGC to withdraw that direction and to get all the necessary information to determine how the confidentiality relationship between SIS and its banks and the banks have been broken. I want to give you the assurance that we are going to fight this war on two fronts. If this state of affairs continue, they're going to be both a public battle. We're going to mobilize the country. We're going to get the trade union movement involved. We are going to get social groups involved. We are going to get Democracy Watch involved. We are going to get civil rights group involved. We are going to have public meetings. We are going to have demonstrations. And we are going to do that because we want the country to know and we want to put pressure on NGC. We are also going to fight on the legal front. I have been given NGC some time to consider this matter, and I want to make a call today for NGC, because I'm not interested to go and file an action, because it would seem to me that these companies have to deal in the future with NGC. And therefore, you do not want that kind of litigious relationship. So I want to be able to give this some time. But I think we have given them sufficient time. So I want NGC to take steps to correct the wrongful interpretation by it and by the banks in respect of the court order. And NGC can assist by clarifying the wrong impression which may have been given in respect of this matter. I also want all the banks to study and consider the terms of the order, and they must take steps to ensure that the orders, that what is happening now in making it difficult for the companies to operate, what they are doing is not in conflict with the order. I know that the banks are aware that it is a serious matter for banking relations to be interfered with without any real reason. I also know that the bank knows that there are recourses which companies have to, in effect, ask for the licenses of the banks to be revoked. Since NGC is a state agency, the Minister of Energy ought to take steps to ensure that her cabinet colleagues are aware of these matters, and the cabinet ought to get legal advice, since the actions or inactions of NGC can have adverse effects not only on these companies and not only on the 800 workers and their families, but can have adverse effects on the public interest. I also call upon the central bank to tell this country if it gave any direction to the banks in this matter. If it did, I want to tell them that they ought to tell the country that. If they don't, well, we will have to find out. But I would ask them in any event to reconsider those directions if it gave, and to give the right directions, because it is the duty of the central bank to ensure that the bank carried out their duties with a fiduciary and confidential relationship in accordance with the law. So, my brothers and sisters and those who are listening to this broadcast on the radio, what we are dealing with here today is the lives of about 4,000 people. If this problem is not resolved, there is every likelihood that the lives of 4,000 people can be affected. If this problem is not resolved, you have companies in this area which can be affected, and it can affect the public interest. We cannot allow this to happen. I have taken off my lawyer's clothes a little bit in this matter, and I've started to talk to some of the trade union leaders. I have started to talk also to some of the civil groups in the country, and some of the political parties have spoken to me. I won't tell you who they are, but some of the members of the opposition parties have spoken to me, willing to lend their hands in order to fight this battle. If this becomes necessary, we're going to mobilize a national movement in order to stop a precedent which, if we allow it to continue, can cause a police state in Trinidad and Tobago to be the order of the day. If at any time you can have people, property being affected and their rights being affected without a court order, then what is happening is a naked violation of the Constitution, is an overthrow of the Constitution of Trinidad and Tobago. And every government takes an oath, every state agency has an obligation to ensure that it upholds the Constitution and the laws of Trinidad and Tobago. Thank you very much, and it is a great pleasure for me to be involved in this struggle.